Good afternoon, everyone, and welcome to Humanities Cafe. I'm your host, Stacy Chidowsha, and we at the South Dakota Humanities Council are delighted you could join us. On any given day, all you have to do is turn on the TV or radio, pick up a newspaper, or just go online, log into your online account, and you'll find news related to today's topic, the U.S. Constitution. If you are a regular at Humanities Cafe, you may recall conversations we've had concerning the socio-political climate of our nation and its direct link to the Constitution. Historians and scholars overwhelmingly agree now that the United States is currently in a constitutional crisis, and it's a crisis that affects every single one of us. But what do we really understand about this 238-year-old document? Much has been said about the need to update it and the underlying principles of it, but why hasn't that happened? So, returning to share his vast knowledge of the U.S. Constitution and help us understand the current issues regarding it and all the complications surrounding it is renowned historian and columnist David Adler. David, we are welcome. We are delighted to have you here, honored to have you here. Tell us a little bit about yourself. Who's David Adler? What does he do? And how did you get so knowledgeable about this Constitution thing?
Well, thank you. Thank you. That's a wonderful introduction. Thank you. And thanks for having me back here again. I always enjoy participating in your show and always look forward to the questions from our listening audience. Well, Stacy, I've been studying the Constitution for many, many years now, longer than I would care to state publicly, probably. The reality is that I've taught at a number of universities over the years and lectured nationally and abroad and written widely on the Constitution, presidential power, the Bill of Rights. And I've enjoyed doing all this. It's been my passion. So I've been fortunate enough to be able to pursue what I'm interested in and to be compensated for it. And also I've been writing a newspaper column now for the past 4 years, as you know. It's called Constitutional Conversations. It's a weekly column on the Constitution, and I've been deeply appreciative of the support from the South Dakota Humanities Council, and it runs in various states, and now I think 260 straight weeks or so. And it gives me the opportunity to share with the audience some insights into both historical and contemporary constitutional issues, with the aim of trying to better educate the public so that they understand the importance of the Constitution, as you noted, and its application to the life of America and the daily lives of Americans. And so I continue now to do that as president of the Alturas Institute, which is based in Idaho. And what we do is to defend democracy by promoting the Constitution, civic education, equal protection, and women's rights. And so this too has been a labor of love, as it gives me the opportunity then to continue to write about the Constitution and to give lectures around the country. So all is good with me. Thank you. And it's a good day because here I am with you and about to engage in a wonderful conversation with you and our participants. Thank you.
And I want to point out that it is with me and the participants. So if you have any questions, comments, concerns, any of that, by all means, drop it in the chat or raise your hand, and yeah, we'd love to hear from you. There's a lot to unpack, David. As you know, I always have 1.5 million questions for you. So let's start with the basics. When was the U.S. Constitution ratified and by whom? And why did the founders think we needed such a document in the first place?
It's a wonderful question. So the framers gathered in Philadelphia in the spring of 1787 to draft a constitution because our governing constitution at that point in time, the Articles of Confederation, was woefully inadequate to the needs of the nation and not able to provide a satisfactory government to confront the many problems that beset the nation. And so the framers gathered in Philadelphia, spent 4 long months throughout the summer heat in Philadelphia to draft this Constitution, which endures, as you noted at the outset, 238 years later. It took a mighty effort to convince many Americans to ratify the Constitution, but that's precisely what we, the people, did during the long ratification debate. It took roughly two years to bring it off. And then, of course, the Constitution was set in motion. It was easy for Americans to read it because, after all, the Constitution proper consists of only 87 sentences. That's it. And so Americans were pleased with the Constitution. The ratification coincided with the resurgence of the American economy, and so many people linked the successful writing and ratification of the Constitution with the resurgent economy, and thought that the nation was indeed very fortunate to be governed under this new document. And many throughout the years over the past 2 centuries have hailed it as a brilliant masterpiece in the art of government. Not perfect by any means, but nevertheless a work that people could be proud of and to which they could look as a model for governance, because it employed various mechanisms for checking and balancing government, the separation of powers, enumeration of powers, checks and balances itself, all to harness the government and to ensure that it behaved in a way that the American people expected it to, and that was to adhere to the supreme law of the land in accordance with the terms of the Constitution. And that's been the constant struggle, hasn't it, over 2 centuries, to require the government, all governmental officials from the president to members of Congress and so forth, to adhere to the terms of the Constitution. And so it has not been perfect, as we noted. The framers observed that they had done the best they could in 4 short months. Seemed very long to many of them, but 4 short months to draft a brilliant document from a blank canvas, so to speak. But one of the wisest things that the framers did, Stacy, was to include Article 5 of the Constitution, which is the amendatory clause, leaving it to subsequent generations of Americans to improve upon their work. And so the framers, as smart as they were not so arrogant as to believe that they had captured for all time all the provisions that ought to be employed forever and ever, but understood the shortcomings of the document and left it to we Americans at any juncture in our history to improve upon their work, to change it to meet the needs of our time. And so we have an opportunity as participatory citizens to hold government accountable, to urge it to adhere to the Constitution, and when necessary to critique and criticize it. And of course, at this juncture in American history, as everybody knows, the Constitution is in crisis. It's in crisis precisely because leading governmental officials are violating it frequently, ignoring its terms. Other governmental officials are not guarding it sufficiently. And so, as you mentioned, so rightly, scholars and historians are deeply concerned about the status and indeed the future of the Constitution at this very moment.
And I think the term, I remember from my early education, the Constitution being referred to as a living document. And is that because of the framers' intention for it to be changed as needed?
Mm-hmm. Yeah, that's a great question. Many scholars, judicial scholars and others, refer to it as a living document precisely because A, we can amend it at any point. We've only done it 27 times, not many times, but it's very difficult to do. But B, the Supreme Court has the responsibility to interpret the provisions in light of the ongoing needs of the nation. And indeed, as everyone knows, we face new emerging issues that didn't confront the framers. They couldn't possibly have dreamed of the kinds of technological, sociological changes that we've undergone and enjoyed, frankly, across 2 centuries as we've improved our country, made it more democratic, extended the franchise, extended rights to people who were all but ignored under the Constitution. And so the document must be a living document. If it's dead, it doesn't serve the needs of our country. And of course, that invites squabbles, doesn't it? Invites debates about how to read and interpret the Constitution to ensure that it's not the case that the court is importing new values not grounded somehow in the Constitution. That's always the aim, I think, to ensure that the court in one way or another is grounding its rulings in the terms of the Constitution, within the four corners of the Constitution, we might say, and is able to explain how its decisions are in fact firmly rooted in the provisions of the Constitution.
You noted that there's been 27 amendments ratified, and when I was looking through all the preparatory stuff I was reading for this segment, I found that there's been 12,000 amendments proposed on the floor of Congress, and only 27 have been ratified. And then there was, I believe, 6 that they're just still hanging out there. They weren't ratified at all. They were introduced and not ratified. But I think most of us are familiar with the Bill of Rights, which is the first 10. And those were all included at the same time, right? How did that come about?
That's a great question. It's amazing to think that we've had so many proposals, 12,000, as you point out, but that reflects invigorated minds, imaginations, desires on the part of many to improve the document, sometimes perhaps for good, others for ill. But the first 10 amendments, as you point out, the Bill of Rights, were a function of the fact that toward the very end of the Constitutional Convention, in the last weeks in September of 1787, some members of the convention started asserting the need to append or include a Bill of Rights. And that engendered a debate, and some members of the Constitution, very strong members, heavyweights, we would say, said that a Bill of Rights was not necessary because the government was limited to those powers allocated to it. It could not go beyond the lines of the Constitution, so to speak, and so it wasn't necessary. But those who urged the necessity of a Bill of Rights said, well, wait a minute, some rights are actually preserved in here. It says, for example, the government may not pass ex post facto laws. And so are we to think that the Constitution is going to preserve some rights, but not, for example, the magnificent rights of freedom of speech and freedom of religion and due process? Aha. Those who thought that the Constitution did not need a Bill of Rights were sort of caught. They were on the hook, which led James Madison, whom we justly referred to as the father of the Constitution because he played the leading role in drafting the document, said, listen, if the Constitution is ratified, we promise, meaning he would promise personally, to introduce a Bill of Rights in the first Congress. And true to his word, on June 9, in 1791, he did precisely that, introduce the Bill of Rights, and 1789, excuse me, and introduced the Bill of Rights. And lo and behold, within 2 years, it had been ratified. And thus we have the 10 amendments, which reflect those most precious rights, as we've said: free speech, freedom of the press, freedom of religion, due process, and so forth. And to many, that helped to complete the Constitution, so that if we could have taken polls at that point, Stacy, as historians tell us, we would find a very, very high level of popularity, that the Constitution was very popular among the American people because it seemed to have overcome the woes of the Articles of Confederation. It strengthened the national government. It eliminated and in some ways hobbled the state powers that had afflicted the national government and left it unable to confront the problems. And now look at us. We have a Bill of Rights. Here we go. Charge. We're looking forward. The founders knew many problems lay ahead, but they believed that they had a basic tool now to govern the nation, and there would be reasons for optimism. Of course, there were many voices that warned that republics don't last historically, and many were concerned that this great experiment, and it was an experiment, as you and I have discussed before, might not succeed because there might be usurpations of power. There might be corruption in government. There might be negligence. There might be an unwillingness of the American people to properly examine the actions of the government and speak out and hold it accountable. So we crossed our fingers filled with optimism, but the founders were realists as well, and we charged forward.
Now, the 13th through the 15th Amendments are called referred to as the Reconstruction Amendments. What does that mean?
Right. Those are vital amendments to the Constitution that in many ways fundamentally changed the nature of the Constitution. They reconstructed the nation in the aftermath of the Civil War. The 13th Amendment eliminated slavery. The 14th Amendment, the majestic 14th Amendment, dramatically changed the nature of federalism in this country and provided that no state could deny to any person the equal protection of the law and due process of law, or deny the privileges of citizenship. And the 15th Amendment provided the vital fundamental right to vote, because if you don't have the right to vote, you can't really participate in our system or hold governmental representatives accountable. So the 13th, 14th, and 15th Amendments, the Reconstruction Amendments, reconstructed the nation, changed the face of federalism because it transferred to Congress awesome powers that had formerly been in the hands of states. And this was necessary to protect the rights of the newly freed man. If Congress, for example, under the 14th Amendment, Section 5, had not been given the authority to pass the laws to enforce the terms of the 14th Amendment, then states could have ignored federal laws and could have continued to treat blacks as inferior. And of course, it didn't fundamentally alter the relationship between blacks and whites. That took a long time, another century before we had the passage of significant legislation. And that's marked really the defining struggle in our country, I think, that is race. And it continues to be a problem that bedevils us even to this day, particularly as the Trump administration has eliminated the basic rules and norms and conventions for ensuring access for minorities to the reins of power by prohibiting any program or law that would give any credence to diversity or equity or inclusion. So the struggle rages on, and it mark, Stacy, the very first words of the preamble to the Constitution, in order to create a more perfect union. Ours is a pursuit, isn't it? We continue to strive to improve our union, and we're doing that now, we hope.
So in speaking of current issues in relation to the Constitution, there's quite a few, as you pointed out, but the 22nd Amendment is particularly apropos to this conversation. What does the 22nd Amendment do?
It certainly is very, very timely to discuss that. The 22nd Amendment represented the determination of first Congress and then the American people to impose a term limit on the president, limiting the president to 2 terms. And that was a function of the fact that President FDR had been elected to 4 terms in office, which really rankled the Republicans. And so the 22nd Amendment is often referred to as the Republicans' revenge. But it was more than that. It was also a reaction to the forces occurring in the world, where executives across the globe were accruing greater and greater power. We had obviously defeated the fascists in World War II. Autocrats loomed large. There was always the fear of an ascendant executive who might acquire or usurp powers not granted to that office. And that marked a historical concern, as you know, from the discussions and debates in the Constitutional Convention, because that generation lived in dread fear of a powerful executive. They had known tyranny personally, firsthand, under King George III. They were keen students of history. They read widely, and they knew that executive power always threatened liberty. And that explains precisely why the framers created a relatively weak office, not a strong presidency, but a weak office. And anybody can compare Article 2 to Article 1 of the Constitution, which is the legislative article, and realize that the president was only granted few and meager powers. We often forget that, in part because we're told so often that the president, in the case of Donald Trump, who claims that he has, quote, unlimited or absolute power under Article 2, which could not be further from the truth. There's no evidence to support that. Nobody in the convention urged the concept of absolute or unlimited executive power. And indeed, the entire history of the Revolutionary War and the run up to the Constitution reflected fear of an executive. And the last thing the framers were going to do in Philadelphia was to recreate on American soil an embryonic monarchy after we had just fought a war to free ourselves of an absolutist king. So historically, then, there were all kinds of concerns about executive power. And finally, the Republican-controlled Congress pushed through the 22nd Amendment. It was obviously ratified by the American people. And I think it's been very healthy. There remains a debate, and a few presidents and other citizens and members of Congress have urged repeal of the 22nd Amendment because it does impose term limits. It limits the right of the people to choose their president. But as we acknowledge a historical lesson, and that is the longer somebody's in office, the more likely they are to abuse its power. It's almost a function of human nature. That's what history teaches us. And so I think the Republican Congress wisely trimmed the sails of the presidency by limiting it to 2 terms. There has been some speculation, of course, that President Donald Trump would seek a 3rd term. He has said occasionally he would. His supporters have urged him to. There's no basis in the 22nd Amendment to permit it. So it could not be done lawfully. It could not be done constitutionally. It would have to be done as an authoritarian action.
Thank you for that. So we talked about the Bill of Rights, which is 1 through 10, and then the Reconstruction Amendments are 13 through 15. And in between there is a sneaky little 12th Amendment, which is interesting and consequential. And that is, I'll let you explain what it is, but why was it included?
Well, it was important to include that because under the terms of the original Constitution, it was possible for a president to be elected from one party, a vice president from another party. And there had to be a mechanism for resolving the problem of what happens if no president wins the majority of the Electoral College. And of course, that happened in 1800 when President John Adams and Thomas Jefferson were caught in a standoff. Neither won the majority of the Electoral College, and under the amendment now, the election was sent to the House of Representatives. And under that amendment, the House could proceed to vote state by state to decide whom the members of Congress would like to elect as president. And as it happened, each state got just 1 vote, which meant that if a state delegation, let's say South Dakota's state delegation there was no South Dakota at that point, of course,
Yeah.
but hypothetically, if the South Dakota delegation was deadlocked, 2 Democrats against 2 Republicans, and they couldn't agree about which candidate to support, the state would lose its vote. And so there would be all kinds of reasons to negotiate, to find out who was the least unacceptable candidate, perhaps. And so what happened in the election of 1800 is that it took 33 ballots before the House could elect Thomas Jefferson to be president. And that was a huge moment because up until that point in time, the party known as the Federalists had won each election. They had dominated the political landscape from the presidency to state legislative bodies, and thus the complete turnover in both the presidency and in Congress now led people to characterize that election as the revolution of 1800, not a violent revolution, but to follow in terms of Aristotle's teaching, it's a revolution because it involved a fundamental change in values. The country shifted their attitude and viewpoint toward the role of government. And so that was a historic election, proved to be pretty wise, and it was a pivotal moment. and it was full of shenanigans, which makes it a colorful vote in the House because President Jefferson, or Thomas Jefferson, and his running mate, Aaron Burr, running under what was expected to be the president vice president banner. Everybody expected Burr would be the vice president. When they received an equal number of the votes in the House, Burr started sensing, maybe I could actually be president, not Jefferson. And so Burr, who knew no boundaries, started working behind the scenes and making promises to members of Congress. You vote for me instead of Jefferson, I'll give you this and that. Jefferson caught wind of it and, of course, was very angry because Burr was supposed to be the number 2 man. But that, by the way, provides insight into the appetite of politicians for political power, doesn't it? Well, Burr had a lot of enemies, as we know, one of whom was Alexander Hamilton. The two of them would later fight a famous duel to the death. But at that point in time, Hamilton, who was no friend of Burr and certainly no friend of John Adams, even though they were both Federalists, started lobbying his fellow Federalists in the House of Representatives to vote for Jefferson rather than his party member, his party colleague, John Adams, which really angered Adams. But the two had many feuds. And so it was a good example of how somebody could work behind the scenes to affect the outcome of that election and change the fortunes of the nation. And it's interesting for us at this point in time to note that Jefferson and Adams, who had been the best of friends, close colleagues, when they both worked to write the Declaration of Independence in 1776, had maintained a close relationship until the government was launched, and Adams was a Federalist and Jefferson was not. And the two had very different opinions on all kinds of issues, foreign and domestic. And they entered a very long period in which they didn't talk to one another. And everybody thought this is a shame. The two great titans of 1776, the pillars of strength to help forge independence, wouldn't talk to each other, didn't correspond. What a tragedy for the nation. Years after that, a few years after that, a mutual friend, a doctor, Benjamin Rush, began to work behind the scenes to bring those two together again. And beginning in about 1808, the first signs of a renewed correspondence occurred. They maintained a marvelous correspondence until they both died on the 50th anniversary of the Declaration of Independence on July 4th, 1826. John Adams, on his deathbed, in his last words, said to his family gathered around, "Jefferson lives." What a moving Hollywood kind of last gasp sentence from his mouth, by which he meant the Republic endures. He didn't know that Jefferson had already passed. So it turns out to be a calamitous election, a revolution in 1800. Bitter foes, once great friends, renew their relationship. Great for the two of them, great for the country, and their correspondence is available in little books. So it's a great story. And as we now soon begin to celebrate the 250th anniversary of the Declaration of Independence, no doubt people will be talking many times about that relationship that represented a wonderful symbol for the ability of the nation to be one, to be torn apart, and to be one again.
I think about, because I guess in my thought process, prior to the 12th Amendment, that meant that the president was whoever got the most votes and the vice president was the runner-up, right? So imagine if this was like not created. We would have had recently, we would have had Obama-McCain, Obama-Romney administration, then a Trump-Hillary Clinton administration, a Biden-Trump administration, and then now we would have a Trump-Harris administration. So how do you think that would affect the current political climate in our country? Would that be good or bad? Or a little both?
Yeah, that's a wonderful question. And that's a great what if story, isn't it? And the reality is the two wouldn't work together much. The president would likely send the vice president abroad endlessly and to go to all kinds of events, state funerals, deliver a lot of elementary school speeches in countries far removed from the United States. So the vice presidency would essentially cease to function. Of course, at this point, we all know that in various terms of the presidency, some presidents have greatly involved their vice presidents. Other vice presidents have done very little. The trend in recent terms has been for a vice president to be more involved. That was really started by Jimmy Carter, and it's continued, I think. And now I think it's clear that under the Trump presidency, J.D. Vance plays a large role, at least publicly he does. So it was wise to put the nation beyond that kind of an arrangement where there would be ongoing fighting and would certainly lead to the diminution of the office of the vice presidency.
I want to take a minute here to see if anybody has any questions. This is your chance to hear it from the expert. If like I said, if you want to raise your hand or drop a question in the chat, we would be happy to address it. Okay, well then we'll move on. The next thing we'll kind of want to steer into what's going on now. So a lot of the attention is being paid toward the health of the current president, and therefore talk of the 25th Amendment has come to the fore. Can you tell us a little bit more about that, what it is, when it was ratified, and if there's a particular background or history or story behind it?
Yeah, that's a wonderful, wonderful question. And you're right. Many people are talking about the 25th Amendment. It's all about an effort to remove a president who, during the term of his and someday her term, will be unable to discharge the duties and the functions of the office through illness, through a disability. And the nation came to this conclusion really. It was Senator Birch Bayh from Indiana, who led the way after the nation realized that at different historic moments, we were without a fully functioning presidency through illness and disability, or at least a president whose ability to discharge all the grave responsibilities of the office in less than in a full and energetic way. And the story would begin, of course, with the presidency of Woodrow Wilson. After he suffered a stroke, he was debilitated for at least 6 or 7 months. And so his wife and the Secretary of State simply assumed many of the responsibilities. Not to say that Mrs. Wilson, Edith Wilson, acted arbitrarily. She knew where her husband stood, and she would consult with the Secretary of State. But they weren't forthcoming. They certainly weren't going to tell the nation that Wilson's stroke was so severe that he was really confined to his bed. And occasionally on better days, they would sort of prop him up, comb his hair, and invite photographers in to take photos of him when he could talk to the reporters. And thus the nation thought, well, the poor president had suffered a stroke, but he's on the mend. No need to worry. It was only many years later that we did indeed worry about it. After that, of course, we had a number of presidents who were ill in office. FDR was failing shortly after he was reelected to his 4th term. And very few knew of his severe heart condition, and he was in grave health, although I think that many would agree that he performed superbly all the way to the end. But Churchill, his close friend and ally, observed that he knew that he was dying almost from the first time he saw him after he was reelected, and aides were seeking to protect him. And then Eisenhower suffered a heart attack and was down for a time. We later learned, of course, of all the maladies affecting John Kennedy and how he was taking so many pain pills just to get through the day, in addition to other medications that might have undermined his ability to act at full speed. So the awareness of all these afflictions, and among others, and the ability to think ahead. What happens if a president were to become disabled and not able to discharge the duties and possibly not want to leave the office because of dementia, for example, because of such a cognitive decline that nobody could persuade the president to leave the office what to do. The nation couldn't be caught in such a starry state of affairs. So the 25th Amendment then, engineered, as I say, by Birch Bayh very effectively in 1967, tried to solve these problems. Not easy to do, and the method for removing a president under the 25th Amendment is very complicated and very politically doubtful, let's say, because it requires the decision of the majority of the cabinet to agree and to sign an agreement that the president can't discharge his duties and should go. And then it proceeds to Congress, giving Congress the opportunity to make the ultimate decision. But the reality is that it's unlikely that somebody would be removed under the 25th Amendment unless we see that president on national television speaking gibberish, drooling down his chin, and that's not likely to happen. And Harry Truman observed that if his cabinet tried to remove him, he would fire everybody. There would essentially be an exercise in defense. So the 25th Amendment is unlikely to be invoked, but it's very serious, and I'm glad you raised it because so many people, and I'm in this camp, have noted the cognitive decline of President Trump. Experts, health experts, psychiatrists, and others can note how he uses fewer and fewer words. His sentences are becoming shorter and often incomplete. He speaks in terms that remind us of a cul-de-sac. He goes round and round on the same point again and again, offering nothing new when he's answering questions. And people wonder as he stands before audiences if he is diminished, and if so, how much? And of course, that raises a powerful question. And of course, it comes home because, of course, as everyone knew, Donald Trump was fond of attacking his predecessor, President Joe Biden, for his cognitive decline over the last several months of his presidency. So it's an important issue, and the question is how to deal with this. And what many scholars have argued is that there should be an independent medical team created, authorized by Congress to conduct an annual exam of the president, physically, mentally, that is, examining the cognitive skills, because it's in the interest of the nation to know we have a president who's sharp. And to add one more point here, everyone knew, for example, in the last couple of years of his presidency, that Ronald Reagan was declining rapidly. That's why he didn't hold press conferences, answered all questions from either a teleprompter or little note cards. And during the Iran-Contra affair, when the special prosecutor Lawrence Walsh and his team were questioning President Reagan to see if he knew what occurred in the Iran-Contra affair, it led Walsh afterward to say to his team, either Ronald Reagan is the greatest actor we've ever known, or he didn't know anything about the Iran-Contra affair. I'm not sure which is true. It seems very likely that the dementia that his aides were talking about was overcoming the poor president. So lots of reasons to have a 25th Amendment, but very difficult to invoke. So thanks for asking.
Sure. The last time we met on Humanities Cafe was in July, I think, and we discussed the constitutional crisis we're in now. In the weeks since then, much has happened, including the deployment of National Guard troops to U.S. cities. And I want to talk a little bit about that. And there's a couple of questions in the chat regarding that. Jim asks if the military can defy a presidential order. And Janet asks, how is it that the president has control of state National Guards? I always thought they were under the control of governors. Is this a federal state rights issue?
These are great questions, and they go right to the issue of the moment, don't they? The first thing is that officers swear an oath to obey the orders of the commander-in-chief, and to defend the Constitution, rather. They swear an oath to defend the Constitution. And therefore, while it's expected that they will obey the orders of the commander-in-chief, they are not permitted to obey an unlawful or immoral order. And that's important because that means that officers have an independent responsibility to decide for themselves whether an order is lawful or not. And that's important right now, for example, in light of President Trump's order to attack and destroy 4 boats from Venezuela, clearly in violation of the Constitution and international law. And already within the ranks of the military, there are serious questions about whether the military would attack a 5th boat because it's so clearly violative of the law. However, having said that, it's very difficult for trained officers, highly disciplined, trained in the order of command, to resist carrying out an order. And therein lies the rub. Does a president expect that all the officers, the rank and file, will obey his orders? Trump ran into a problem in his first term when, during the protests, as a result of the protests that we call Black Lives Matter, when lots of protesters gathered at Lafayette Park across from the White House, and Trump didn't like it, and he asked then Mark Milley, who was the chairman of the Joint Chiefs of Staff, can't you just shoot them? And Milley says, no, we don't do that, and the military doesn't play a role in domestic law enforcement. Those are powerful words. They haunt us still because historically, as Mark Milley says, the military has been prohibited, with very few exceptions, from engaging in law enforcement. And that goes all the way back to the Posse Comitatus Act of 1871. But more than that, the tradition that says we have a civilian government, not a military government, and the military is expected to defend the country against enemies, external enemies. So when President Trump now, as the second question has asked, has decided to federalize the National Guard, he does so under Title 10 of the U.S. Code, which pertains to the military. He did it in June in Los Angeles. He has now done it in Portland. He's doing it in Chicago. He has sent troops to Memphis. Other cities are likely to be cities where he deploys troops as well. The question is its legality. A federal judge in the Los Angeles deployment held that Trump had acted illegally, and so too did the recent judge, Karen Immergut, in Portland. Both agreed for the same reason, and that is that the deployment of the federalization of the National Guard and then its deployment must occur within the confines of Title 10. And there are 3 conditions that have to be met, and both judges agreed that he had not met those conditions. The first is there an invasion of the country that would allow the president to federalize and mobilize the National Guard? Answer, clearly no. No invasion of the country that would warrant that. Second, is there a rebellion or an insurrection? Obviously not. Nobody can confuse the 36 protesters in Portland, who are largely peaceful protesters in full compliance with the law and thus entitled to First Amendment protections of free speech and assembly, with constituting a rebellion or an insurrection. And then we come to the third category. Are there combinations of forces so large and powerful as to prohibit the president from executing the laws of the nation, the federal laws? The answer, again, is no. It's a small group of protesters. And so Trump has been, his actions, his deployment has been held to be illegal. But the question, I think, by Janet is a good one, because typically the National Guard is under the control of a state governor who is commander-in-chief of that state's National Guard. There is an exception, as I've mentioned, when in times of crises, it might be necessary to call out the Guard. What we're now waiting to see, because Trump has threatened to do this on several occasions, whether he would invoke the Insurrection Act, which is similar to Title 10, but it goes beyond it and allows the president to deploy the troops even over the objections of a state governor, if he determines that the illegal forces are so powerful and so arrayed against the government as to close down the ordinary proceedings of justice, including closing the courts. Well, nothing like that has happened. But in my view, Donald Trump has deployed more troops, in this case, the Texas National Guard, now numbering 500 or more, into the streets of Chicago because he's interested in provoking violence between peaceful protesters and members of ICE who have provoked the protesters by firing pepper spray at them, shooting a pastor. And because if he gets that pretext, then he can invent the idea that there is a crisis that justifies his intervention under the Insurrection Act. And so that's wholly cynical, so as to create it by attacking the protesters who would at some point then want to defend themselves, as we all would if we're on the streets of America and we're the victims of a robbery, for example, or somebody's trying to beat us up. That's the parallel. And if he obtains that kind of pretext, then he would exploit it for his purpose, and that is to invoke the Insurrection Act.
You mentioned, and I just really briefly want to touch on this because I have one major question that I left that I want to for sure ask you, but you mentioned Title 10 of the U.S. Code, and Stephen Miller earlier this week had said that under Title 10 of the U.S. Code, the president has plenary authority, and then he stopped. What does plenary authority mean, and is he right?
Yeah, good question. I'm glad you asked. The answer is absolutely no. Plenary authority would mean absolute authority. But of course, he's no constitutional scholar. He's no legal scholar. He's not interested in American law or adherence to the Constitution. So he is simply fabricating the idea that the president has absolute authority in keeping with, we should remember, Donald Trump's own fabricated argument that the president has absolute power or unlimited power under Article 2. The Constitution is foreign to claims of absolute power, just as we don't have absolute rights. We're a system of mixed powers and rights. But what we're really thinking about here is Stephen Miller's effort to diminish the ability of protesters and opponents to undermine Trump's policies and arguments. It's the same Stephen Miller who just this week said that those protesters are really, quote, domestic terrorists. Now, there's a public official who speaks in utter disregard of the law of the United States. Protesters, peaceful protesters, as we've said, are protected under the First Amendment. Congress shall make no law abridging freedom of speech, freedom of the press, or peaceable assembly. And that's what these folks are doing. So what you have here in very candid terms, Stacy, is an authoritarian denying the rights of the American people, exalting the absolutist claims of a president who has no interest in adhering to the Constitution, but a president who's only interested in pursuing his own goals of concentration of authority in his hands. And this goes back to the very early point you made during the introduction about how scholars are concerned that the nation has plummeted into a constitutional crisis. And indeed we have. That's because the president is usurping, fancy word for stealing, congressional powers, and the GOP-controlled Congress is sitting on its hands, not challenging the president's theft of its lawmaking power, taxing power, spending power, oversight power. And so if in fact the GOP-controlled Congress, we're talking specifically about the Republicans here because they're in the majority, Democrats are in the minority, are arguing against it but have no authority, then what we really see is the gross decline of checks and balances. And if you have a president who can freewheel it, unchecked by a Congress who indulges the usurpation of its power, then it means we are facing the worst kind of crisis you could imagine. And we're running out of the kinds of institutional constraints that the framers created to protect against the rise of an authoritarian president. That's where we are, and that's why most legal scholars will say we're in a crisis, and it's frankly terrifying, because what we're left with now is just the lower federal courts, who have done a good job. And people should know that some 200 courts have held Trump's actions illegal or have imposed injunctions to stop them. And those have been judges who have been nominated, indeed appointed, by presidents from Reagan to Trump, including Trump-appointed judges. So it's important. It can't be said that these are, quote, left-wing radical judges, as Trump and Miller and others often say. The real troubling part here is that there are people in power in this country, in the Republican Party, who have taken an oath to uphold the Constitution, who are negligent in sacrificing, surrendering the powers of the institution, which the court has said is itself a violation of the Constitution. Some of those people, I should say, come from your state and your neighboring state, North Dakota. And so when the Senate Majority Leader, Thune, participates in the abdication of the congressional power to wield checks and balances to ease the path of a president to an authoritarian end, really we ask why. That's the big question, why? The framers, as we would say, would be rolling over in their graves at the thought that Congress would so clearly abdicate its powers and responsibilities. That's why we're in a crisis.
And I'm glad you mentioned the judiciary, because when I think about, I have my constitutional law textbook from back when I was in college, and I think about, there hasn't been any amendments in that whole time, so technically it's still relevant, right? I mean, this is an old book, but there hasn't been a significant amendment to the Constitution in over 50 years. So what's the role of the judiciary in that, and how has that exacerbated the level of polarization we see in today's society?
Yeah, thank you. I'm so glad that you can so frequently recur to your constitutional law class. It tells me that was one of your favorite classes.
Absolutely.
You admired your professor. You were lucky. You had a very good professor, and you continue to refer to your constitutional law book. I love it. I love it. The judiciary doesn't have much of a role in the amendatory process, because it's formally provided that Congress would, of course, introduce a constitutional amendment, 2/3 of both the House and the Senate. And then if it passes the Congress, then it's sent out to the states or to specially held ratifying conventions for approval. And as you'll recall, it's a high number. 3/4 of the states have to approve. So it's very difficult to amend the Constitution. The reality here is that the courts, by updating the Constitution, have in many ways not foreclosed resort to the amendatory process, but in many cases have diminished the need for resort to the constitutional amendment. And that's what you're undoubtedly thinking about, because if the court updates the Constitution to keep it current to the needs of the time, then in fact we don't need to amend the Constitution. So if the court does hold, as it's held, that the Equal Protection Clause applies to all people in the United States, and says that the Due Process Clause applies to all people in the United States, then we don't need an extra amendment to say, well, the Equal Protection Clause now applies to Blacks and to women and to others, because it would be laborious and unnecessary. So the court, to respond to your good question, has a role in updating the Constitution. If, however, the court doesn't render rulings that keep the Constitution current to the needs of the time in the minds of the American citizens, then the move is on to amend it. And one good example in the minds of many is the continued effort to pass the ERA, the Equal Rights Amendment, because women still do not enjoy the full constitutional rights that men do. They're still subject to discrimination because the laws against sexual discrimination and harassment simply aren't adequate. The discrimination against women in the workplace, for example, still are less than adequate. So in my view, we still need ratification of the ERA. In this case, the court hasn't gone the full 9 yards in granting to women the idea that the 14th Amendment Equal Protection Clause means no gender discrimination at all. That's just one example.
And that the ERA is just one of the 6 that were left unratified, right? It's kind of just hanging out there for a while.
Yes, that's right. And of course, there's an argument that when the Virginia legislature ratified it 2 years ago, became the 38th state under the terms of the Constitution, met the criterion that it should have counted, but other states had withdrawn their ratification, and so there'd be litigation over the question of whether states can withdraw their ratification or whether it needs to be re-ratified by states. So it's lost in arguments, and probably what we need is a renewed effort by a future Congress to propose yet another ERA that would then be submitted to the states or specially held state ratifying conventions to approve it.
In terms of, like, we're running short on time, so I just really want to kind of put a nail in it and say, what as everyday American citizens, us everyday Joes, what can we do in relation to the Constitution to save our system of government and by extension our nation at this point?
Well, that's a wonderful question. The reality here is that as American citizens, we have the right and the responsibility to hold government accountable. It's our duty as citizens. We're blessed to be citizens and to have the power to scrutinize governmental actions and to speak out when we disagree and to criticize and to offer proposals for changes. It's not easy, particularly in these times, to hold government accountable, particularly at a time when members of Congress shun the idea of holding public meetings. They don't want to hold town halls because in many cases they would be severely criticized. So it makes it difficult, but we have to continue to speak out and exercise our First Amendment rights and take advantage of the opportunity to write letters to the editor, to continue to be a spark plug for public discussion of civic affairs. And even though it can seem bleak at times, the ability of Americans to hold government accountable and to stand strong for constitutional government is perhaps best achieved now through participation in the mass protests that are occurring nationwide. And I'm thinking again of this Saturday, No Kings protests, where people from coast to coast, millions strong, will do that. And there is strength in numbers. And governmental officials recognize this. It is the heartbeat of democracy for Americans to exercise their First Amendment right to peacefully protest, and that's what the No Kings protest is all about. So it's a very difficult time, but you asked the right question at the last moment in our time together. And I'm just reminded, Ben Franklin came out of the Constitutional Convention in 1787, was asked by a woman, said, "Tell us, Dr. Franklin, what kind of a government have you given us? A monarchy or a republic?" And he looked at her and he said, "A republic, madam, if you can keep it." This is our moment, Stacy. It's on our shoulders to keep the republic.
Okay, thank you so much. We are out of time. Thank you so much for joining us again, David. I always learn so much when we have these conversations. And there's still so much to talk about. But our time for this week's cafe is over. Again, thank you so much. And thank you all for joining us. If you're available in a couple of weeks on Thursday, October 23rd, I hope you all will join us again. We are going to have as a guest Dr. Richard Kite, who's going to come and talk to us about the meaning, not meaning as in definition, but the meaning. How have we become so mean? How we just don't, we're seemingly more cruel to each other. We don't have as much empathy. a compassion, understanding, and stuff like that. And he's going to tell us kind of why that is and what the role third places have in bringing around a solution to that issue. Again, thank you all so much. I know we're over time. Thank you so much for joining us. Thank you again, Dr. David Adler. I appreciate you more than you know. And
Thank you
everyone,
for having
enjoy this beautiful fall weather.
me. Thank you.
Thanks, everybody. See you next time.
Bye.